Belinda. I'm the Director of Latin American and Latino Studies. And today I have the privilege of introducing Professor Kim Ricardo. She is a Professor of Law and Interim Associate Dean of Experiential Education at UIC Law School. She is a graduate of the University of California, Berkeley. I also graduated from Berkeley. Very partial. The University of Hawaii at Manoa, the William S. Richardson School of Law, and Georgetown University Law Center. She joined the UIC faculty of law in 2008 and has also been a visiting professor at Seattle Law, UNLV, and DePaul. At UIC, she teaches classes on criminal law and procedure, lawyering skills, and seminar classes on race, gender, and class. Professor Ricardo's scholarly writings consider redress and reparations law, policy, and social movements in the United States, and her recent articles consider U.S. and Argentine abortion laws and policy from a comparative perspective. So before becoming a lawyer, Professor Ricardo was an actor and performing artist in both theater and film. She is also a published author. Her poetry appears in Mananda magazine and in the 2001 Underground Railroad Calendar. In 2012, her piece Truth Commission was shown at the School of Art Institute's Sullivan Gallery as part of an exhibit titled Opening the Black Box, The Charge is Torture. So it's a real pleasure to have Professor Ricardo here.
So thank you, Dr. Linda, for that introduction. Before I start my talk, I also want to thank Latin American Latino Studies and GWS and Dr. Gutierrez over there for arranging for the invitation to talk. I appreciate it. So, I was just telling Jonathan earlier, for me, this is huge to be invited to talk to your department and to be an affiliate member of the GWS faculty. The law school has just recently joined the university, and this is one of the really great benefits to that union, despite all the bureaucracy and things that are not so great. One of the people who has molded me, I think, as a thinker, is one of my very good friends from high school, her sister, Marcy Miranda, who went to Berkeley. And the reason I say that is because when I was probably a freshman or a sophomore in high school, she brought home from Berkeley with her a book called Haciendo Caras, and it became like a Bible for me. And so to be able to speak to this department and to be a member of the university is just a real privilege. So before I sort of start talking, I want to just make the announcement that I'm from the law school, and I'm not sure what the culture is here. I talked about this earlier. But when we give talks at the law school, they're generally about 20, 30 minutes kind of at most, and then we go into a discussion. So that's kind of the plan that I had for today. Now, if I go over 30 minutes, if somebody could kindly just raise a hand. And so I'll just kind of wind down in response, because I'd really like to have a conversation. Obviously, the topics that I'm talking about are still ongoing, in particular here in the United States. If you take a look at the timeline handout that I shared with you all, you'll note that today, a district court in Texas, a federal district court in Texas, is hearing arguments about mifepristone, right? One of the two most used abortion drugs for medical abortion, not only in the United States, but across the world. So let me tell you a little bit of background about sort of like how I came to this subject, right? In 2016, I started traveling to Argentina for personal reasons. But as a result, I was able to witness the national campaign for legal, safe, and cost-free abortion happening in the streets. So I was there in Buenos Aires in 2018 when the first Senate vote sort of was lifted up and failed, right? And it was a huge disappointment to be in the streets and to witness and experience that disappointment. A couple years later, in December 2020, I was probably like many of you in lockdown at home. I was on the floor of my living room watching the live stream of the Senate debate that took place over something like 14 hours until 4 o'clock in the morning, local time, and I think so that would have been like 1 or 12 midnight, depending on daylight savings here. And I was there, and, watching the live stream, and sort of crossing fingers, and then all of a sudden the announcement was made, and then cheers, applause, and then immediately the bass line of Hasta la Raíz by Natalia Lafourcade, and it was just a lot of emotion. So I guess I want to say that I sort of have a personal stake in the conversation, and I think in December 2020, much of the feeling on the ground in Argentina was, finally, right? After all of this time, after decades of grassroots organizing and bringing together different social movements, finally we've caught up to the rest of the world, right? Because of course in 1973, the United States Supreme Court had declared that abortion was a fundamental right? Little did we know then, or maybe some of us kind of had inklings, right, that how precarious the right to abortion in the United States actually was. Because only 2 years after that, right, we have the United States Supreme Court in a case called Dobbs versus Jackson Women's Health, essentially eliminating that right nationwide. So a little bit of what I'm going to talk about today is sort of give a little primer into what's happening in the United States. I'll begin with a history and then get to sort of the present day kind of quickly. And then I'm going to sort of at the same time try to point out some events that are happening sort of throughout Latin America, but really focusing my attention on Argentina. And then we can have a discussion. All right. So I'm looking at two different screens here. One of the things that I want to also kind of point out, right, is I'm going to be making a comparison between the movement for legal, safe, and cost-free abortion that won in Argentina, and what happened in 1973 here in the United States. And so this is Benedict Cumberbatch, Sherlock Holmes. At least that's how I know him. In the summer of 2022, in anticipation of the Dobbs decision, he appeared on Saturday Night Live, and at the end of, with the curtain call, he got, many of the cast members from Saturday Night Live to put on their 1973, commodified activist shirts to signal their support for abortion rights in the United States. I think this is really interesting because of what, to me, Roe actually meant and means, right? Because I think that, sorry, here we go. I think that Roe certainly was a symbol, remains a symbol of abortion rights in the United States. But if we actually take a little bit of a deeper look into what Roe actually said, and we'll discover, especially as we contrast what Roe said to the IVD law in Argentina, we see how lacking, right, the standard in Roe was. So let me begin my primer about the legal history in the United States, to the extent that it's helpful both for the lawyers and the non-lawyers in the room, and then I'll go into sort of a comparison a bit with Argentina. So in 1973, the Supreme Court, essentially made abortion legal throughout the United States. Because in a decision that had national impact, the court identified a fundamental right to privacy, which also recognized, by sort of extension, recognized a right to abortion. Importantly, in my view, Roe is not a sort of a feminist opinion, right? At the very heart of the rights rhetoric in Roe is not the pregnant person, but rather the physician, right? And so this is why this quote is here. Abortion is not in the court's eyes in Roe a quote woman's choice, right? But rather a medical decision that a doctor, the physician, was in the best position to make a decision for their patient, right? Some other interesting kind of parts about Roe, besides being physician-centered, I want to point out a couple of things because from a legal perspective, the standard for constitutional scrutiny that the court applied in Roe was the highest level of constitutional scrutiny, what we call strict scrutiny. What this means essentially is that when states try to pass laws, right, that might run counter to the fundamental right to privacy and therefore the fundamental right to abortion that was announced in Roe, strict scrutiny means that any state that wants to promulgate any restrictions to abortion access are going to have to establish to the court that its regulations are, one, narrowly tailored, and two, narrowly tailored to serve a compelling government interest. This is the highest level of scrutiny that the court applies in its constitutional jurisprudence, and set a really high watermark for this new right, right? It also sort of applied this kind of sliding scale approach in thinking about competing interests, right? So on the one hand, you have the pregnant person's interest in her bodily autonomy, the right to an abortion as mediated through her physician, right? And then on the other hand, right, the court also recognizes a potential of life, right? But they're going to weigh these two competing values out differently depending on how long the pregnancy has come, right? What we see almost immediately after Roe is an erosion of the very values contained within Roe. So, for example, in 1977, so just a few short years after Roe v. Wade was decided, you have Congress passing what we now know as the Hyde Amendment. The Hyde Amendment was sort of a rider to an appropriations bill that essentially said that no federal funds would be used in any abortion services, right? In 1980, the Supreme Court heard the case challenging the validity of the Hyde Amendment, and the court says, Congress can do whatever it wants. Congress doesn't have to fund abortions. Just because we say that a pregnant woman has a right to choose an abortion doesn't mean that the state has to fund that person's choices, right? So already a very stark contrast to the campaign in Argentina, which one of its central principles was the right to a legal and a safe abortion doesn't mean anything if it's inaccessible because of finances. Right? So, if you look at the timeline, right, we have this high water mark in 1973, but almost immediately we have an erosion of these principles. So 1992 comes along, right, and there are challenges to Roe. States are promulgating different creative abortion restrictions. Many states, as we realized last year, retain their abortion bans, right, in anticipation of Roe being overturned. But in 1992 comes another very important case when it comes to understanding what the sort of landscape looked like prior to dogs, right? And that's Planned Parenthood v. Casey. Now remember I said before when we were talking about Roe v. Wade that the constitutional scrutiny standard was this thing called strict scrutiny, right? What the Casey court did was eliminate that and replaced it with this sort of strange undue burden test, right? That is to say that the court is still going to apply this kind of sliding scale approach when it comes to evaluating or weighing out the two competing interests of bodily autonomy and sort of like this incipient life, right? But what the court says here is no longer are we going to sort of evaluate state legislation regulating abortion access on this strict scrutiny standard, but instead we're going to use this undue burden standard, right? That is, state regulations cannot put a sort of ambiguous undue burden on a person's right to access abortion. Also, importantly in Casey, what the court did is sort of get rid of the trimester kind of sliding scale approach, and what it did is mark fetal viability as the critical moment before which no state would be allowed to outright ban abortions, right? Now, because of medical technology, obviously, right, that fetal viability marker is sort of a moving target, but currently the National Institute for Health calls that at about 24 weeks, right? In any case, that was the sort of strict kind of doctrinal rule when it came to evaluating abortion restrictions and bans coming from the states, right? Because again, states were relentless. But this was sort of the law, right? And then comes, well, I'll come to this later. Then comes Texas SB 8 in 2021, right? This is the most creative, most imaginative piece of legislation. What it was essentially was a ban on abortions after the 6th week of pregnancy. It was passed the Texas legislature and was signed into law by the governor in May of 2021, right? The real sort of innovation of Texas SB 8 was it did not rely on state enforcement of the ban, right? So government, police had nothing to do with the enforcement of this abortion ban. Rather, it empowered you and I, everyday citizens, to be essentially citizen prosecutors. What we all sort of are familiar now is this idea that in September of 2021, almost a year in advance of the Dobbs decision, right, is when Roe actually fell, right? Because the Supreme Court did nothing and allowed SB 8 in Texas to become law. In so doing, it eliminated the sort of nationwide protections for abortion access that it had previously announced in Roe and continued on in Casey, right? So when we think about when Roe fell, it wasn't Dobbs, it wasn't June 2022, it was September 1st, 2021.
Sorry,
Yes.
can I ask you something? The Supreme Court, what was the reasoning for upholding it? It was procedural, wasn't it?
It was, well, yes. Essentially, the arguments for the constitutionality of SB 8 weren't actually given the same type of audience that normally the Supreme Court sort of hears, right? In especially high-profile cases like a right to abortion case. The September 1st, 2021 decision was a result of the court's, quote, shadow docket, where the court just makes an announcement, unsigned, about the resolution to this decision. So yes, in a way, the court sort of doesn't really give like a great explanation, but it was about sort of, to the extent that there was an explanation, it was about there's no case here, essentially. The SB 8 hadn't been sort of utilized yet, and so the court kind of abandoned, in my view, right, abandoned its responsibility to protect a right that it had announced in Roe. Please feel free, if you have any questions during the presentation, also to ask. So that leads us then to 2022 and the Dobbs decision, right? Which is kind of, I think, in many folks' minds, the case that explicitly overrules Roe. Though the decision in 2021 certainly got rid of Roe protections in Texas. So it overrules Roe v. Wade, which was very startling, I think, to any legal observer, because the principle of stare decisis in the law is meant to encourage some stability, uniformity, predictability in the law, right? And this is something that the court does in very sort of short terms and doesn't give a lot of thought, except to say, let me try to go back here. When it comes to, the question of was Roe rightly decided, the court says that there is no fundamental right to an abortion anywhere in the Constitution, right? Not sort of recognizing that, of course, fundamental rights aren't articulated explicitly in the Constitution. And then, referencing very briefly this test for fundamental rights, which is that a fundamental right has to be a right that is, quote, so rooted in the traditions and conscience of our people as to be ranked as fundamental, right? Which is a fairly subjective test. But after 48 years or so, of 2 generations of people with gestational capacity growing up in the United States with this right, one might argue that it was in fact something deeply rooted. If not in 1973, that's arguable, certainly in 2023, or 2022. So back to Dobbs, abortion is not a constitutional right, and very importantly for the lawyers, we moved in Roe from strict scrutiny on abortion regulations to undue burden standard in Casey to all the way down to rational basis review in Dobbs. What that means is there's a huge amount of deference that the court, even if it takes up challenges, is going to give to states in terms of their ability to regulate and even ban abortion, right? Because rational basis means as long as there's any good reason that the state wants to impose a regulation on abortion, that's good enough, right? So essentially the state can essentially do what it wants. So that's what we have in terms of that's what we have in terms of the United States, right? In the historical kind of legal historical primer. I want to, keeping all that information in the background, now spend a little time talking about what's happening in Argentina and then by extension other parts of Latin America, right? So the big difference in terms of, if we take as a symbol this 1973 as a campaign for abortion rights in the United States, and I know that that's not the whole story, right? But if we take that as a sort of mainstream approach to protecting abortion rights in the United States, we see how sort of empty I think that concept is when you compare it to the history that we've seen now that erodes a pretty weak principle in the beginning, at its inception, right? As compared to this really robust, intersectional sort of, wraparound kind of understanding of the types of needs that pregnant people have, and the role that the state is obligated to play in protecting those rights, right? So, of course, we've already seen the national campaign for legal, safe, and cost-free abortion. But the sort of subtitle to that campaign are the words that you see here, right? Sexual education to choose, contraception to not abort, and then legal abortion to not die, right? It is not just about the right to access abortion for the sort of feminist grassroots movement of the national campaign in Argentina and elsewhere, right? It is more than that. It is about all of the sort of cycle of life, right? Contributing to the options that are available to someone when they're faced with an unwanted pregnancy. So, keeping that in mind, right, on the penultimate day in December 2020, in the middle of the pandemic, we have the voluntary termination of pregnancy law passed. The Senate in Argentina, decriminalizing abortion throughout the country. But also, and sort of lesser known, is at the very same time, the Senate, the vote in the Senate for the IVE law was 38 in favor to 31 against, right? This 1,000-day plan that passed at the very same time, the very same day, was unanimous, right? The 1,000-day plan coming along with the voluntary termination of pregnancy law in Argentina is to me really significant. And so what the 1,000-day plan provides are direct financial payments to pregnant people throughout the course of their pregnancy, as well as direct payments for the family and children up until sort of early infancy, 3 years old. The idea is that the state has an obligation to people who decide to have children to make sure that so not only are there direct payments, but access to free medicines, vaccinations, food, milk in particular, but there's a recognition that the state has an obligation to support and make a real choice for people when they're deciding whether or not to keep a pregnancy. So that's the 1,000-day plan. I want to talk a little bit more about this as we get into a discussion, but I think that the real lessons for us in the United States now, right, looking back at our experience, at the way that we were able to achieve the abortion right in 1973 and what are we going to do now, is to take a look at the strategies used by the activists and organizers in Argentina and other places, right? Not only was the focus on changing legislation, right, in the IVE law, but also litigation played an important role. But those are just two, smaller things, right? In particular, I'd like to sort of focus or maybe talk about in discussion the administrative regulations about the technical definition of what health means. Because as you're all aware, many abortion bans in the various states include exceptions when the pregnant person's life or health is at risk, right? That was true in Argentina before 2020 as well. But how do we define health? How do we understand health? And how did people access legal abortion in Argentina before 2021? Because although it was very restricted, it was happening, right? So let's actually just turn to that now so we have some standards to talk about, right? The World Health Organization defines health really broadly, right? And I want to call your attention to the fact that the WHO defines health as a state of complete physical, mental, and social well-being, and importantly, not merely the absence of disease or infirmity. So when we sort of try to draw some practical lessons from the Argentina experience, I think this is one big one, right? that there are already arguably many ways for us to provide needed health services for people wanting to terminate their pregnancies within the bounds of the sort of explicit law. And so I kind of want to end with the formal part of my talk with these sort of images because I think like I tried to sort of suggest earlier, the campaign for legal, safe, and cost-free abortion in Argentina was not merely the result of a single issue campaign, right? But rather the success of the national campaign was a result of many different traditions of grassroots organizing, coming together, realizing what sexual violence had to do with reproductive justice, what had to do with trans rights, what had to do with the rights of indigenous communities. All of these conversations were happening at the same time and created a lot of movement and an actual change in the public discourse on the ground in Argentina. I think which is an important thing to kind of keep in mind. And finally, right, I think that one of the things that looking at Argentina, obviously I don't want to kind of portray the image that everything's great in Argentina and people have complete access and full choices, right? Because that's certainly not true. Argentina is currently dealing with, I think, some of the big issues are what to do with conscientious objectors, right? Not maybe so much an issue in terms of abortion access in the capital, but certainly in the more sort of rural provinces, a big continuing issue. And then, if you're familiar with Argentina at all, you know how terrible the economy is right now. There will be a presidential election at the end of this year, and we will see sort of potentially, right, a major shift in sort of the political winds. And I'm very sort of anxious to see what a major change might do in terms of the state resources that have been devoted to plans, social services programs kind of like generally, but in particular this 1,000-day plan that I discussed with you. Okay, well, thank you very much for that part of the talk. But now I'm very excited to be able to have a dialogue, a conversation.
And get a change in government, which is possible. So how precarious are the rights there in that sense?
Yeah, so it's a really great question, and I think that I happened to be in Buenos Aires last year when the Dobbs decision was first leaked, and then it was released. And so a lot of folks on the ground were asking questions about, oh my God, can this happen here in Argentina? We just fought this decades-long fight to get the abortion right, and so my answer is I think that because of the democratic process, the majoritarian political process that Argentina went through in order to get the IUD law, it seems it's going to be much more resilient to any court challenges, but also to any kind of political challenges as well. I say that because I think one of the great strengths of the campaign in Argentina was that it involved people, right? You really could not go anywhere without seeing the green handkerchiefs, without understanding that there was this ongoing national debate about abortion access. Not only because, as I said before, the abortion question was very important, but also because it was tied to all of these other social movements, right? So, there are different ways that things become law in the United States, right? through congressional legislation, sort of nationwide, right, is one major way. And then the United States Supreme Court making declarations is another way. The sort of way that Roe v. Wade was decided, I think, was flawed in many respects. But in one respect that it, kind of procedurally was flawed, is the court the only case in front of the court at the time in Roe v. Wade was the Texas ban against abortion. The court in Roe v. Wade could have foregone declaring sort of a national solution and only answered the question in front of it in Texas. It decided not to. Right or wrong, it decided not to, right? I would never say that, rights, human rights, should be up to the whims of 9 justices on the Supreme Court. But right or wrong, they made this decision, which had the immediate impact of kind of mobilizing anti-rights groups in the United States who fought the long battle, right, and eventually won again through the courts. And I think that's a major lesson for reproductive justice activists in the United States to consider, right? That this kind of work of, changing the public discourse, getting public buy-in, changing attitudes, right? For example, away from a framework of, sexuality and individual choice into a social justice framework about human rights and healthcare, right? That was a major shift that we, I think, are still in the United States kind of struggling with.
Can I ask you about the role of organized religion? Because you can have sound legal arguments, you can have sound social policy, and organized religion doesn't care for things to be sound. They just care about
Right.
the orthodox ideas, right? And in Latin America, for instance, the Catholic Church is particularly vicious when it comes to abortion. Also in the United States, the Catholics and evangelical conservatives, right? And they don't mind to wreck the Constitution, to wreck the legal system, as long as they get their way. So how do you deal with that part in the abortion program?
Yeah, so interestingly, right, is something that I learned, maybe not interesting to everybody, but interesting to me as a lawyer, is the Argentinian Constitution is based in the American Constitution. That is, it's a mirror, at least the original version was a mirror of the United States Constitution. Except for one big thing, right, whereas there is, a separation between church and state in the United States, in the Argentine Constitution this is a Catholic country, right? It's baked into the foundational document of Argentina. And certainly that's a big concern because as you mentioned, right, a lot of the anti-rights organizing, coalesced around religion, the Catholic Church in particular. What in anticipation, I think, of this, right, what the activists on the ground have done for years is make the argument that this decision about whether or not to have an abortion is not a religious decision, that it is something that they're asking the state for support, just like they would ask for health care in other sort of arenas, right? And that the church ought to have no influence over this, non-religious decision, right? Just like marriage, for example, right? Which again, we forget that Argentina had the right to marriage equality 5 years or so before the United States did. So that, I think that's an important part of the discourse, right? The sort of separation between church and state. That happens in the schools as well, right? We talk about sort of the education system and sexual education. Again, sort of a separation between the church should have no role in determining what's taught in school, what happens in terms of government policy, etc. There are still churches, but that's the limited realm. Of course, there are
sounds very naive, but why doesn't that happen in the States? How is it that so, you know, I'm not going to but I thought that.
Yeah, I don't think it's a naive question at all. I think it goes to, history and politics, and
but how do we get to this point
yeah.
where religious issues rule in a country that was supposed to be founded on the idea of religious freedom, and why isn't anybody mad about this?
So, yeah, I mean, when you look at the original Roe decision, right, it was not a close decision like we see other Supreme Court decisions in recent past being, right, divided sharply against, political lines, right? The author of the opinion, Justice Blackmun, was a Nixon appointee, right? I think 7 out of the 9 justices who made the decision were Republicans. It was just, abortion was controversial, and maybe always will be, but that decision was penned by, people representing all sorts of political stripes. I think what we also have to keep in mind, in particular as we think about what do we do now, right, in the United States, is that we see this attack on rights, not only against women and the right to access abortion, but also against people of color more generally in these sort of voter suppression laws throughout the country. Right? One of the arguments that Mississippi made, made successfully apparently in the Dobbs case, was that this question should be a question left up to the states because the Attorney General argued it's easier to get agreement in the states. It's easy, there are sort of cultures, state cultures, etc. I think the same is true when it comes to liberalization of abortion laws in the 1970s. What you had at the same time, right, is the civil rights movement had gained a lot of legislative victories in the Civil Rights Act, the 1965, the 49th Act, etc. And so what you see is, I think, and I'm not a historian, but my sense is that what you see is a sort of backlash, right? That there have been strides made, and then you have a backlash. Ronald Reagan played a really important role in this. When he ran against Jimmy Carter, he realized that even though there was broad Republican support for women's rights in general and also the abortion rights specifically, that he could win votes by courting the religious conservatives, and that has become a big plank in the GOP politics.
There was actually a very interesting episode in the media, on the media, this last Sunday, about the growth of evangelical property and how it grew in the Reagan era and so on.
I mean, as you mentioned human rights, of course I have to bring it up.
You want to introduce yourself to folks in the audience?
Oh, I'm Sara, and I am at the law school, Sara Lavinanda. I'm the director of the International Human Rights Clinic and also faculty. So as you were presenting and we're having this conversation, I think it's important to sort of highlight that even how these decisions, right, sort of the right to privacy was used in the U.S. for us in Argentina and in so many other countries that have been successful in advocating for reproductive rights. It has been anchored on the right to life, on the protection from violence, on the right to health, right, which in human rights are different. And so I think you were asking about how can it happen, right, that we have such distinct outcomes, and I think the right to privacy is a weak framework for reproductive health. versus the right to life, which is fundamental, right, and the right to be free from discrimination, which is really, really important in the organizing by so many organizations in the Argentine, in the experience and the fight for reproductive rights and freedom from violence, really.
Yeah, absolutely. So I'm really especially pleased to have Sara and Elena here from the law school because they were, readers of early drafts of the paper that we're talking about. So thank you for being here. Right, and I just want to highlight one of the things that you said about the privacy right. In many ways, the court in 1973 was kind of stuck with privacy as being the legal framework for recognizing the right to abortion. But it wasn't the only framework it could have chosen. We have the Equal Protection Clause of the 14th Amendment of the Constitution, right, which would have been a more appropriate legal framework for a variety of reasons that just didn't come to pass. Which is not to say that the equality framework hasn't been utilized by advocates, hasn't been mentioned by justices and judges. The district court opinion that eventually got up to the Supreme Court in the Dobbs case, Judge Carlton Reeves in Mississippi, very explicitly mentions gender equality as being a foundational legal principle in recognizing the abortion right. Justice, let's go, yeah. Alito, Justice Alito, in his opinion, spends the briefest of moments contemplating equal protection before completely discarding it as, a legal doctrine or as a consideration.
So I want to know this, from a comparative perspective, like countries that have enshrined the right to abortion in Europe or a longer period of time, do they normally anchor that on the right to health, or on the right of, or do they, because it's, what I find really perplexing is that each legal system with its own idiosyncrasies in a way anchors this particular right on and that's a real, for us foreigners, the way in which Roe v. Wade was argued, it's just it's insane, right? Because instead of saying, well, it's the right to health, basically, it's the right of women, or the right to life of a woman if the pregnancy has certain, entails certain dangers. Instead of that, they look at sort of the back door to try to argue a case. And that's just, it seems that in the end, to the extent that the right to health is not even thought as such in the U.S. legal and social culture, if you will. Therefore, you have to argue in a different way that, in a way, can make you justify such a way the case for this particular sort of idiosyncratic legal system. But in the case of other countries, what right do they invoke? Is it right to health? Is it right to life? What is it?
Yeah.
Switzerland or Sweden or Germany?
Yeah, I'm less familiar with sort of the European countries. I'll say in the Argentinian context, it is not just one sort of single right? It's an incorporation of many different rights. The human right to health, the human right to life and bodily autonomy, the human right to access public health care, right? All of those are bound in the decision. And it's also something that the Supreme Court of Argentina, in challenges 10 or 12 years before this case, or the IDE law came to pass, because the Argentinian Constitution, as it's been formed, incorporates specifically various human rights instruments internationally, right? And so kind of draws in to its way of understanding, the abortion right, all of these different frameworks, which is, has proven to be a lot stronger, I think, than just this really weird right to privacy that has collapsed now.
And then something else I wanted to ask you has to do with the sort of alignment of public opinion's view on the matter and then the legal system. So in Argentina, there seems to be Argentina seems to be moving, like the rest of Latin America, into alignment. Values have changed, as you know, Cristian was. I mean, we are both Chilean, and we know that Latin American societies are very conservative, or used to be very conservative. Things have changed, and then as a result of that, has been a realignment. And countries like Mexico or Argentina, that 40 years ago or 30 years would not even have thought about this, are moving in that direction. What really strikes me again as a foreigner is, look how the opposite sort of trajectory is being observed in the U.S., because most of the people are in favor of some sort of, and then the legal system sort of operates against that, and there's no political cost for that, at least for now, or there was some, but in the end it seems like a radical faction in a way was able to institutionally sort of impose on the rest of society a ruling that in a way is not reflected on people's views.
Yes, I think that your observations from somebody outside of the system are very apt. Yes. I think also another factor here is the media, right? I think the media in the United States loves like a battle. They love versus kind of situation. And that's really simplifying things, right? So the pro-choice versus the pro-life movement, I think that makes for really great headlines and an easy way to sort of present arguments, but I think it's much more complicated than that. And I'd also say that though the litigants who brought Roe to the United States Supreme Court really did rely on this framework that was available through privacy. That's how we got, by the way, birth control through the privacy right, which also makes it very possible that we could get rid of contraceptives as a being protected. Even though that was sort of a narrow legal argument that those litigants were making, it's also always been true in the United States that there were movements for reproductive justice led mainly by women of color who rejected that framework, right? Who argued that this is not going to end well, who argued we need to think of something more comprehensive here than just this one right.
I had a comment to that. I mean, I think in Latin America there has been a very strong tradition on social and economic rights, right? And so, for example, Chile, Argentina, Colombia are in the forefront of environmental human rights. And I think even though it is they have strong religious traditions, on the other hand, understanding that social protections is within the realm of the responsibility of the government. And so I think that is very different in the U.S., whereas the framework is more civil, political, instead of economic, social, and cultural rights that must also be protected. So when you mention Sweden, right, I mean, like so many countries in Europe as well have a strong social and economic sort of framework that falls into the responsibility of the government. And that is why you have positive rights that include the responsibility of government to establish an infrastructure where sort of people can enjoy, right, have full enjoyment of those human rights.
I mean, what is really interesting in the case of the States, though, is that, I mean, it's not that as if you never had a welfare system. In the 30s, you had one. It's just that it wasn't constructed on this idea of having the right to education or the right to health. But if you compare them, regardless of the discourse that many Latin American countries have, the U.S. has had a much higher level of protection of its population, at least part of the population, than Latin America, even though it didn't, in a way, conceptualize it as such, because socioeconomic rights were sort of always like a dirty word. But it's quite counterintuitive, because I think people make a lot of what has happened in Latin America, but in reality, as you were pointing out, many of the protections are also only in name, unfortunately. Because there are no resources, because there are many aspects of social welfare have become privatized, for many reasons that are sort of difficult to. So I think it's not a linear story in either case, unfortunately. And what strikes me about the U.S. is like the disalignment or misalignment, I don't know exactly what to say, between public opinion and how like values in society, what people think in society, and the way from an institutional point of view the discussion is going. That I find just perplexing, incredibly frustrating, and also like so intrinsically problematic.
Really quick, what I'll say to that is I think that we also can't underestimate the dynamic of racism in the United States and how it affects public opinion towards public goods, right? There's great historical work done about, everybody loved public libraries, public schools, public pools until black people could use them, right? And then sort of like, oh no, we've got to, privatize, or we've got to, find ways that we can keep these things for ourselves and not share them essentially.
Yeah, I was just going to comment on that, on the kind of disjunction between public opinion and the law that is being created. I think partly goes back to something you said earlier about kind of a lot of conservatives playing the long game. And I think one of the long game has been eroding, that you also mentioned, kind of voting rights and all these different things that have allowed, so for example, in a state like Wisconsin, where Democrats and I think there's probably more Democrats than Republicans, yet if you look at their legislature, it's overwhelmingly Republican because they've created laws that essentially weaken the votes of large numbers of population, including people of color. And I think you see that playing out in numerous areas across the country, so that you have exceedingly conservative legislators, partly because of the way voting districts are gerrymandered, and a population that's not as conservative as people that are living in that area. And I think that has had a huge impact in terms of the politics and what gets passed in the more conservative population in our region.
I have a question about the definition of fundamental rights that you shared with us. Isn't there a very flawed definition in a certain way? I was thinking, for instance, I was thinking about indigenous rights. They're never treated as fundamental, right? So for even Ginsburg rule in favor of rights of discovery against indigenous communities. So it turns out the indigenous people will never make this test because they're not enshrined in people's consciousness that they should have any rights. So isn't there a problem with defining fundamental rights that way?
Yes, this is a test that was articulated by the Supreme Court, right, in terms of, it has to do with, the way that our Constitution in the United States was written it's a very short document, right? It fits on one piece of paper originally, and probably still might, depending on how big that piece is. It's way more than a fit. Right, kind of mechanically, the idea about recognizing rights that aren't enumerated specifically in the Constitution happens through this vehicle of fundamental rights, right? That there is this sort of gray area in the Constitution, maybe like bright yellow area in the Constitution, where we can kind of find the constitutional roots, and we can conjure them up from, the sort of, background, the penumbras, right? The substantive due process, right? So that's where this test comes from, right? Which means that it's flawed, but it's also maybe not flawed from the court's perspective, because the whole idea of the legal system, right, is to maintain the status quo, right? And so if you place a very hard to achieve standard out there, then you're going to be able to better maintain the status quo and make it much more difficult to change.
And when was this written, this test?
I believe this is from like the early 1900s. in cases that had to do with some, you know, workplace protection laws.
And of course, another problem is how do you define our people?
Yes, right, and there's a, by the way, this is more than you want to know, there's a big sort of disagreement in whether the people of the United States means the people who reside in the United States, only the citizens of the United States, maybe including some of the nationals of the United States, or who? Yeah, who count as people? Because corporations are now people, by the way.
Yeah.
Would it also be the movement in Argentina with here multi-generational, or is there a difference between the Jews? Was it, I saw the photo of the younger people in Argentina.
I think that's a great point when we try to skip over there, right? I think a very significant part of the campaign in Argentina is that it's multi-generational. So in the handkerchief there, right, you see the image of a white handkerchief, which of course is a recognition of the madres of Plaza de Mayo. So that, you know, a recognition and a sort of active kind of sort of invocation of that history of activism, of organizing. And, you know, you also have important moments in the campaign where, you know, members of the mothers of the Plaza de Mayo were joining actively, right? And I think that's really significant because most women in the United States who seek an abortion are mothers. And they're seeking an abortion because they want to be able to provide better resources for their existing children. And so having the mothers play a big role in not only the iconography of the movement, but also sort of in the political discourse about the movement was really important, because you're not separating motherhood from you know, this abortion right? In fact, it's a way to strengthen the bond that a mother might have with a child, a parent might have with a child. And then so, you know, there above is another kind of poster from Colombia, which of course says, you know, maternity will be wanted, or maternity won't be, you know. And so neonamenos, right, if you've got the mothers of Neo Plaza being sort of the progenitors of the campaign, neonamenos is kind of like the younger sister, right? In 2016, when the marches for neonamenos first began, right, it sort of injected a lot of energy, youth movement into the campaign. It wasn't absent before, but there was a sort of, you know, revitalization, I think, from very young people who are very connected to the neonamenos movement. And again, right, that's sort of kind of weaving together concerns about femicide, gender violence, et cetera, into this idea of reproductive justice, into the idea of abortion.
And Ni Una Más was for femicides.
Yes.
So that was the slogan for in Latin America, Ni Una Más. So I think that was a clever way, right, to anchor it into the violence against, sort of the freedom from violence against women.
So are we lacking that here?
Yes.
Yes, I think so. I think so, because, you know, I invited a lot of young students that they're talking about indigenous rights and women's rights and all kinds of rights, and I invited them, and they're not here.
Do you know, I think that there are probably lots of reasons for that, right? But maybe one reason is they're part of a generation that they never had to really worry about it as in terms of a constitutional right? It was part of their imagination. And maybe for them, the, you know, they should be probably more concerned, I think.
They haven't felt the pain, like you said, the
Yeah.
community, work hard to create this movement because they were feeling the pain, they were feeling the struggle at all levels. And now there's a different interest, more self-interest sometimes. And the people that are organizing are not saying exactly the right things either, like you said.
Though I will say in the work that I've been doing, by the way, on UIC's campus, there is a group of us, interdepartmental group of us, working on reproductive justice advocacy. In particular, in a state like Illinois where there's a constitutional right to an abortion, this is a public university where many people are seeking abortion health care from our surrounding states and even beyond. But the university probably ought to make a stronger statement than it has about this, the health services, the vital, necessary health services that UIC provides and that they haven't yet. So if anybody wants to get involved in that,
Oh, can you say less information sometime?
Yes.
I think gender and women's studies.
Yes, Jenny's, Jenny Breyer's.
They're having another.
Yes, right after
there's a
this.
program.
I'm sorry.
They're having
Yes.
a panel with indigenous women participating. That's going to be powerful.
Yeah. I mean, it's great. It's very exciting. I just don't need to be part of the university and see all this movement happening. Yeah. Which is, of course, not necessarily, reflected in the on those top floors. We'll see.
You gotta be good.
And if I may ask you, so are you optimistic at all that in the next, like, will come, or are you super pessimistic that things are not gonna?
I think there's cause for optimism because, as you pointed out, right, public opinion is strongly in support of abortion rights, maybe with some limits, but every time that the question has been put on the ballot for voters to make a determination on, they voted in favor of rights, right, in conservative states like Kansas. So that gives me hope. Gives me some optimism.
I was going to say, I hadn't heard of the 1,000-day plan, is that what it's called? Which is really interesting about, mothers and infants and care and that period. So I'm a Texan and many friends and family in Texas, so I follow Texas politics and news. So Texas, we know why Texas is important on this topic. So I've been watching because of the pro-life. So I was expecting this. So is there going to be a baby boom? Is there a baby boom? And what's the plan for the baby boom? Or if there is no baby boom, does that mean people are getting abortions through underground, dangerous, or expensive? And so I've been waiting for the government and religious leaders and flag waving pro-lifers to say, here's our 1,000-day plan and there's nothing.
No.
Or that I've encountered.
Yes. We've had an experiment with a sort of 1,000-day plan in the form of the child tax credits that were expanded during the pandemic, but expired at the end of 2021. So that tax credit was increased from $2,000 per child to $3,600 per child. And what we saw during the period that that program lasted were improved metrics kind of all across the board. People sort of rising above the poverty line, better health outcomes for young children, etc. That program kind of sunset at the end of 2021. But Biden was trying to get this sort of, to be a present kind of program through the Build Back Better Act, Build Back Better America Act, whatever it was. But of course, right, one of his biggest foes in that battle was Senator Manchin from who specifically found fault with those child tax credits, saying that if we're just, the very familiar, individualistic, bootstraps kind of conservative rhetoric, if we just give people money, they'll stop working, etc. And he comes from like one of the poorest states in the country, where, his constituents would have greatly, had been benefiting, could have continued to benefit from that. But yeah, it to me, right, the reluctance or the total disinterest in formulating an analogous 1,000-day plan in the United States just, to me, betrays that it's not about whole life.
Well, I hear people fighting for gun rights all the time and loosening the gun rights and all kinds of gun ownership deregulation and so forth. But I haven't heard anything remotely about something like this. Mothers and infants and babies and conflict.
So one thing that I find very striking in both applications, and I think that a connection could be made with the Me Too movement, right? Because the Me Too movement was about sexual violence, sexual harassment, also gender discrimination, but mostly about sexual violence, right? But what strikes me about the Texas law is that, what do you call it, making your neighbor could potentially be your prosecutor, right? Well, I think there's a link there, right? And I don't know if there's a possible legal contradiction with this idea of undue burden, but it seems to me that, like, if you're a young woman, right, who is was pregnant by an abuser, right, or if you're in that sort of situation, like, where it would seem that the stress of being potentially sued by your neighbor or your oppressor or your conservative community, right? Wouldn't that be like an undue burden for, as far as a woman being able to make that decision? And I know it's probably not the same. I don't know if there's a legal case to be made there or not, because I'm not a legal scholar, but I just see that relationship between the sexual violence, right, and that a lot of women that consider an abortion is because they're in some sort of abusive situation, right? So at least a connection can be made there in terms of social movement, right, between those two issues. But I'm wondering, looking ahead, right, is there anything like in the docket, right, with challenges to the 2021 Texas law?
Yeah, so I think maybe the Texas legislature was a little bit maybe disappointed in what happened after SB 8 became law, which is there isn't like a lot of litigation happening, certainly not as much as maybe I had anticipated. There were 2 lawsuits kind of brought against, I'll talk about one. So there was a lawsuit brought by a man from Illinois who sued a doctor in Texas who declared, I've been performing abortions and I'm going to continue to give my patients care after this bill becomes law, because it's my responsibility as a physician. So made himself a target, right? Was sued. The Texas court that heard the case dismissed the case based on this legal concept called standing. That is, this person in Illinois had nothing to do with the facts on the ground and therefore could not sue, had no legal right to sue. So that was kind of, I think, the hope for Texas, that these types of cases would be litigated. Just a few, I think last week, I heard about a case that kind of hits a little bit more of what you're thinking about or imagining maybe, which is the case of an ex-husband suing the 3 friends of his wife who counseled her through getting medication abortion. And so, the standing issue maybe becomes stronger for this litigant, right? Because he's claiming we were still married when these 3 other people intervened to provide aid and counsel for my wife to get an illegal abortion in the state that we live. And that case is still progressing. So I suppose we'll see what happens.
I wanted to ask what changed from 2018 to 2020, where there was that shift from a no vote in the Senate to a yes vote in the Senate. I would imagine it probably had to do something with the elections in 2019, but I just wanted to.
So yes, right, because Macri was the president, a conservative before, but he was the one who sort of opened the debate in 2018. Then you had Fernandez being elected in 2019, and sort of, kind of, I think the political climate changed. But that's not only, those aren't the only reasons. When you look at the sort of legislative record about the debates in the Senate and in the essentially House of Representatives in Argentina, you have people, there's a woman senator whose name I can't remember right now, who said, I voted no in 2018, but I'm voting yes in 2020 because I've understood that sort of the public discourse has changed, and I understand this to be not a question about individual rights, but rather a question about human rights, right, and social justice. I mean, literally says this. I've got it quoted in my article, so you can kind of take a look at it. We also have another from Cambiemos, one of the sort of, I think the president of that political party, that coalition of political parties, says, he's a gay man, right, says, I'm voting yes because this is a debt of democracy that we owe to women and other people who can become pregnant, right? That this is a rights-forward decision. So I think that, when we talk about the political discourse, when we talk about how abortion is imagined kind of socially, that has at least this is what the senators are saying at the time of vote.
Do you think that the issue could be brought again to the court soon? That there are so many things that were debated, like the Andrew Gordon, for example, right? I had lots of arguments about how simply going to a pregnancy is an Andrew Gordon. Right? Even if they give the child for adoption or whatever. Emotional burden of giving a child for abortion if that's the case. And then the burden of having to raise a child if you carry the pregnancy through, like all those things. So why are not I know why that but what I mean is, could those, you see any legal scenario where those things could be raised up again?
If you read the Dobbs opinion by Justice Alito, he actually, considers these arguments, and he says, no, we have these, safe harbor laws where women can drop their babies off at fire stations and nobody's going to prosecute them for abandonment. And we have, these workplace laws now that prevent pregnancy discrimination. Everything is good, is essentially the tone. It's very simple, but the way it stands now, in order, and what you see in states like Illinois, right, are a sort of reinforcement of sort of reproductive justice rights, like the constitutional right to an abortion. You see also debated in states like safe harbor provisions for physicians who practice this important health care so that they don't get sued from people from outside, right? But I think if we want a return to sort of a national protection of abortion rights, we need the Congress to do it almost immediately after Dobbs in 2022, you had, still a majority of Democrats in the Senate, and in the House, rather, and the measure failed. It would have just restored road protections, road case protections, but it failed, right? So you're going to need a lot more to get national protection back.
I think it's just past 1:30, so we're out of time, but I think we